Proof of employment within 30 days, no employment as a home health care provider or with minors, regular reporting by Zoom or in person.
Alright folks, this is where things get real. Judge Simpson starts off by making sure the defendant fully understands the weight of this plea, because one wrong answer here could change everything.
Court is calling 2025 CR 005370, State versus Adriana Ramos. Can I have parties announced?
Rick Pena for the state of Texas.
Orlando Castañón for defense.
And are you Ms. Ramos? Probation, this is an application. Mr. Castellon, did you review all of the discovery with your attorney? I'm sorry, with your client, and have you received the discovery?
I have, Judge.
Court will find that the state is in compliance with discovery. Ms. Ramos, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are proceeding on the lesser included offense of misdemeanor assault causes bodily injury family member.
So, the state just downgraded the charge from what could have been a felony to a misdemeanor. That's a huge deal. It often means the evidence for the higher charge wasn't strong enough or there's a plea negotiation at play.
Any objection?
No, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
The state is proceeding on the lesser included offense of assault causing bodily injury to a family member as a Class A misdemeanor. Range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has been able to assist me in her defense.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Ramos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes. Yes, ma'am.
If you're not a U.S. citizen, by entering into this plea bargain agreement, you will be deported, denied naturalization, and re-entry into the states. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault causing bodily injury family member. There's a $1,500 fine.
Here's something a lot of people miss. Once there's a family violence finding, you lose your right to own a gun under federal law. That restriction can last a lifetime. What do you think? Fair or too harsh?
The state is recommending deferred adjudication. There's an affirmative finding of family violence and there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am, I do.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated primary custodial parent?
Judge, I actually did not discuss that with her. I do believe that currently the children are not within her custody. But
Do you want to have a chance to discuss that with her?
Just so you know, affirmative finding of family violence means that you still have rights to possess your children, to see your children, but in regards to whether you get to be a sole managing or a joint managing conservator, those rights are affected. You still have rights to see your children, have your children in custody. You're not going to be able to be a joint managing conservator.
Meaning I will be able to have custody of it.
That's not, you won't be able to make certain decisions as joint managing conservator if y'all were to go to court and there was a contested hearing over custody. You still have rights to see your children, you still have rights to possess your children and to care for your children. You still have certain duties, but you would not have the same rights to decide as to, if you already go into a hearing as to whether your children are going to be Catholic or not. There's certain decisions you can't make regarding their religious, educational upbringing, certain medical decisions. If y'all were to go into a contested battle, now you can come to an agreement with your husband for other things, but if you were to have a hearing, you're not entitled, because of the affirmative finding of family violence, to be a joint managing servant.
I understand.
Okay.
And is this just until I'm
No, it is continues on even after your probation.
Well, never be able to.
To be a joint managing conservator, yeah, not unless it's by agreement.
Do you want to have time to discuss that? All right, we can go. All right, we're back on the record. So, Ms. Ramos, do you understand the affirmative finding of family violence, what it means and the impact it could have on any civil matters as it relates to child custody? All right, knowing those things, you understand that to be the entirety of the plea?
Yes, ma'am.
All right, and knowing that you still wish to go forward with this plea?
Yes, ma'am.
Defense, is this the plea?
It is just.
State, is this the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, there been any such motion?
Okay.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be 100 hours of community service restitution, the BIPP course, the TAP evaluation, follow recommendations from the TAP evaluation, a MIC evaluation, follow those recommendations in parenting classes. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Sure.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. This time, state is offers into evidence. It's Exhibit 1 with all attachments.
No objection, Judge.
Thank you. And state, have you spoken with the complainant?
We've attempted, Your Honor.
Oh. Ms. Ramos, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
I do, Judge. At the time of this incident, Ms. Ramos was not on her medication. She does suffer from some mental health issues. She has since that time got back on her medication. She additionally has completed a 12-hour anger management course. She has also begun the BIP program and has attended 8 of those classes. We'd ask the court to consider that and allow that to.
And here it is, the moment every courtroom watcher waits for. The evidence has been reviewed, and while the judge could find her guilty, she chooses deferred adjudication, basically a second chance if Ramos stays clean.
Be credited towards her current probation. Additionally, she has been attending NAAA meetings. I believe she has approximately 40 meetings that she has made, and she also has proof of the attendance for the not only the NAA but also for the BIP classes. And she also has proof of that anger management course. She did also try to enroll in the parenting class. I know she has some issues with trying to enroll in that, but I believe that she is on a good step forward. I believe that she's, very willing to comply with probation, and she wants to get back on track. And I think she's done a good job at doing that.
All right. And how often are you going to NA or AA meetings?
I do it at least every day. I do it through Zoom, so I have to set up like a time to where I can just log in even when I'm at work and do that.
And what do you do for employment?
I work at Amazon. I'm in training to be a manager, and I'm a sales associate.
Okay.
And I would note, Judge, she is indigent, and the fine was at $1,500. And I did not address this with the state, but we asked that you either consider lowering that fine amount or probating a portion or the entirety of that.
All right. And where are your children now?
I'm with my mother-in-law.
Okay. Because is Child Protective Services involved?
No, ma'am.
It's easy to forget that behind these cases are real people just trying to rebuild their lives. Ramos working at Amazon and training for management shows she's trying, and judges do notice that effort.
Because when I got out, when I was incarcerated, she paid me a visit. The woman who was doing the
CPS investigation.
CPS investigation. So I got out and I tried to reach out to her. She said it had been closed. There was nothing she could do for me.
And typically, I believe the CPS will close out those investigations if they're with a protective parent. I think that's what the case was.
Well, see, here's my problem with her being a protective parent. And mind you, this is not in my jurisdiction, but from reading the police report, and I don't know if you well, I'm sure your attorney went over it with you, but this is what I find concerning about the placement of your children. It says that the complainant refused medical attention. And then it says MedCom stated that the complainant was high risk, whatever that means. And so they contacted Child Protective Services because he was high risk. You were going into custody. So I don't know if he is with your mother-in-law with the children or not. But what I'm telling you is, in this report, it says that he was high risk, whatever that may mean. So that may not be an appropriate placement for the children. That's all I'm gonna say. I have no control over that. So I'm just letting you know that's what's in the document. All right, this is what the court is gonna do. There's a $1,500 fine that will be probated. You to continue with your BIPP course to complete that. You to continue with your NAA meetings at least one time per week. If you take
Judge Simpson balances justice and compassion here, lowering fines, enforcing programs, but keeping strict conditions. This is the kind of sentencing that aims to reform, not just punish. Do you think the judge got it right?
if you know that it takes you every day to go to NAA meetings to remain sober, then continue doing that. That's not going to stop me from perhaps terminating your probation early. Proof of employment within 30 days, no employment as a home health care provider or with minors, regular reporting by Zoom or in person,